Hi, I'm Jill Taylor. Welcome to Authority, our newest segment on The Wire. Joining us today is Michael Hawley, a real estate attorney with Lyons Dougherty and a frequent contributor on The Wire. Welcome to the show. Thank you for joining us, Michael.
Thank you, Jill. It's good to be here.
Today we're discussing seller's disclosure law in real estate. What constitutes full disclosure may be different depending on which side you're on, seller versus buyer. Michael, can you give us a little bit of a background on the seller's disclosure form and the purpose?
Yes, it's a relatively recent development in Pennsylvania residential real estate law. It was a project by the Pennsylvania Association of Realtors, and there was a great deal of judicial review of it, and the point was to provide a mechanism by which prospective buyers could get a better understanding of what a property involved. The good parts, the bad parts, everything in between.
And it is a very comprehensive form. I have a copy of it here. Quite a bit of detail on everything from roofs, foundations, electrical systems on the house. What type of information needs to be included in here? Are we talking things that somebody may say is a cosmetic defect of the home versus a material defect? What are we looking at being the pertinent information to make sure we've covered here?
Well, the things that are most important are what condition the property is in, what has happened to it, with it, who has lived in it, what they've done while they've been there. There's no one particular part that I could highlight as being the most important. What I would tell my selling clients would be err on the side of inclusion.
Okay.
Rather than try to shade something that may be a little gray, be as comprehensive and informative as you can. There are a lot of reasons for that, but the most important thing is that it gives the prospective buyers a true picture of what the property is or is not. It's not a substitute for a home inspection. You should absolutely have a home inspection for any property you're buying.
And it's not a warranty either about the condition of the home. Isn't it true that this is to the best of the seller's knowledge?
Yes, knowledge, information. There is not a situation or an expectation with a seller's disclosure that the seller should be a construction expert or an electrical engineering person. If they do have specific expertise, they disclose that as well within there.
Are they held to a higher standard if they are a contractor and they're filling out this form?
Absolutely, they would be, because then they know or should know more than the ordinary layperson with respect to what it is that a property involves, what the improvements are, what the perhaps latent defects may be, which absolutely is imperative in terms of letting a buyer know what it is that they are buying.
So pretty much this trumps the old adage, buyer beware.
Absolutely it does. You don't go in with your eyes closed, and this is another tool in a fairly comprehensive process of determining what it is that you're buying.
So a lot of the information here is very detailed. What happens when somebody says, I don't remember when we replaced that water heater. I don't really understand what type of heating system we have. When you come across that, I know Doug and I try to counsel all of our clients on answering to the best of their abilities, telling them that an omission on purpose is the same as lying on the form. But what if they truly don't understand what the question's asking or how they're filling it out?
That's one of the pieces where I think a professional real estate agent comes in, because a real estate agent or the attorney that's representing the sellers can decipher this. These are things that we see in the real estate agent realm and in the real estate legal field that we understand. We may have to shepherd our clients through these things in order to present the most comprehensive disclosure that we can. Although there may be instances in which someone really, truly, absolutely does not know, should not be reasonably expected to know, or simply does not remember.
And I think an example of that would be somebody has elderly parents, they've never lived in the home, the parents have been the only ones that have lived in the home before, the parents pass away, the children inherit the home. They haven't lived in it, but they are required to fill out, to the best of their ability, any information.
An executor or an executrix, or the children of decedents, are not held to the same standard as someone who has lived in the home and owned the home for a long period of time. There are specific blocks to be checked off and information to be included in the seller's disclosure if in fact the person or persons who are completing it is not or are not residents of that home and have not lived there ever, or certainly not for a long period of time. They can't be held to know the specifics of the home in that instance, and there are allowances made for that.
The unknown box on many of these is always an option, but keeping in mind that unknown has to truly be you don't have knowledge of it.
Absolutely true. I don't know is a perfectly acceptable answer if it's entirely true. If it's a way to try to wiggle out of answering something that they'd rather not answer, that presents a big problem.
And I think what a seller needs to be aware of, they believe that in filling out this form, who's going to know what's going to come back to bite me on this one? But we do have ways of checking up, especially in the digital day and age that we live in now. One of the examples would be the CLUE report, the Comprehensive Loss Underwriting Exchange for insurance agents. If you fill out this form and say, oh, we've never had any claims against it, and then the homeowner goes to get home insurance on this property, for 7 years that information about the house could still come up.
It is even more pervasive than that, Jill. Not so much in the realm of data available in different places, but most of us live in homes where there are neighbors nearby. One notable example that I can speak about from years past is I had clients who purchased their first home, young, newly married couple, and as it turns out, to make a long story a little shorter, this home was plagued with basement water infiltration that the sellers had actively concealed and failed to disclose. And as luck would have it for these unfortunate buyers, they purchased and they settled during a time when here in Pennsylvania there was a drought. About 3 or 4 months into their occupancy, there was a storm. And
the perfect storm, unfortunately.
The perfect storm, yes. And they wound up with literally 14 inches of water in their basement. Things started falling off the walls in terms of patches and things of that nature. And as they were cleaning out the ruined materials from their basement, their next door neighbor says, "Oh, did you have a problem in your basement with water again?"
Ooh.
And that entire thing started unraveling. So really, with the seller's disclosure, honesty is the absolute best policy.
And what recourse then did the buyers have at that point? Is there a time limitation?
When they know or should have known of a failure to disclose or willful concealment, then they have a 2-year period from that point in which they can bring an action against the sellers, and in some instances even the agents for the sellers, if that agent or agents knew or should have known of a defect. In this instance, there was no way to say that the agent or agents knew anything of this. They really did not, as it turns out. But the remedy was monetary damages, assessed against the sellers by the buyers for the losses that they incurred in terms of putting a water remediation system in place, damage to the property that they had in the basement that they were assured was dry and serviceable without any problems. These are very, very specific questions that are posed within the seller's disclosure, because basement water infiltration in Pennsylvania is a hot button issue. There are many springs and such around, and it doesn't
may not be active at the time that the inspectors they are looking at it. They may have covered up water spots and other visible signs.
That's exactly right. And it may have never ever happened either. But there are ways in which knowledgeable people can make a determination. Is this pre-existing? Is this an entirely new thing? And there are scientific means that have been accepted by courts to make those kinds of determinations.
Doug and I always say, err on the side of caution. Yes, you need to. If we find out that there is a material defect in this home and the seller refuses to disclose it in the form, we are ethically responsible to let the buyer know that there is a possible defect, or on a worst case scenario, say that we can't represent the seller in good faith and terminate our relationship with them.
That's absolutely true. And you touched on an important topic, material defect. The seller's disclosure hinges essentially on what constitutes a material defect. And the generally accepted paraphrase definition of that would be a defect in the home that would cause a reasonable, ordinary, prudent buyer to either walk away from the deal or to refuse to pay the asking price. And that can vary from one point to another. That can be a bad roof. That can be a defective heating system. That can be basement water infiltration. Something that would give you pause if you were acting on your own behalf. Would you pay this amount? Would you pay less? Would you walk away from the deal entirely?
Right, and I think sellers also need to know just because they disclose something doesn't mean they're responsible for fixing it. The buyer has the option, as long as they're fully informed, they can walk away from the deal.
Or they can negotiate a lower price that takes into account the diminished value of the property.
And I think it's important to say also that this seller's property disclosure has to be filled out, signed by both selling and buying side before a fully executed agreement of sale.
That's absolutely right. And the reason for that is full disclosure. If you don't know what you're buying, you're not dealing at arm's length, and you're kind of hunting around in the dark for a light switch that you don't even know whether it's there or not. So the seller's disclosure is one of the tools used to take the mystery out of what it is that you're buying.
Well, it's pretty clear how important the seller's disclosure form is in every real estate transaction. If you like what you saw today, be sure to subscribe, comment, like, and share. We hope you had some great takeaways from today's episode. As always, we appreciate your time and advice here on Authority, Michael.
Thank you, Jill. It's my pleasure.
And that's all for today's episode. Until next time, I'm Jill.
I'm Michael.
Thanks for watching.